the SIU's Andy Mothibi, who is also going to, or is expected to be part of this press briefing here this morning. We'll hear from our team whether we're going there right about now. All right, I hear that we'll go there in just about a moment. We're expecting, of course, to lead those proceedings, the Kaiser Kganyago. Well, I think that's where we're going there. Let's go there live now, I guess.
Vice Minister. Thank you very much, Program Director, Mr. Kaiser Kganyago, the spokesperson of SIU, my colleague, Deputy Minister of Health, Dr. Joe Pasha, MEC for Health in Gauteng, Menomantu Nkomora Lehoko, the head of SIU, Advocate Andy Mothibi, members of the media, ladies and gentlemen, let me start by apologizing for the DG of Health who could not attend this event because of prior arrangements where we have sent him, and also apologize for the other MECs. They were here on Thursday because we were initially intending to have this conference after the presidential launch, but we had to postpone it. And now they could not come back again. That's why we have got one MEC who is local or the host. Greetings to you and greetings to all South Africans. We call this media briefing to provide a progress report on the ongoing investigation by the Special Investigating Unit into medico-legal claims made against the Department of Health across the country. As a background, around 2015, the health sector experienced an explosion of medical practice litigation cases directed against health institutions, as well as individual medical practitioners in both the public and the private sector. I want to emphasize this because when we scan the media horizon, it's believed that litigation is only happening against the public sector. But it so happened that the investigation we're doing maybe because it's in the public sector only. But as a Minister of Health, I want to emphasize that even the private sector has suffered, and maybe later on at the end I will tell you how. This explosion happens to have coincided with the Road Accident Fund strengthening its systems. It is common cause that the Road Accident Fund had been hollowed out by a multiplicity of claims that brought it down to its knees. And when it went down, in the aftermath of that, legal practitioners who used to litigate against the Road Accident Fund seem to have migrated en masse to the health sector. So in response to this explosion, the Department of Health convened a medico-legal claim summit in 2015. The following is the summary of the background of the summit. It was attended by various stakeholders, including representatives from both the public and private healthcare sector, the legal profession itself, and other health experts. Over and above the Road Accident Fund migration phenomena mentioned above, delegates deliberated on contributing factors and or other reasons for the escalation of medico-legal claims and identify possible solutions. The possible solutions were classified in three broad areas. Number one, patient safety. It was recognized that adverse events do happen in health facilities and practices the world over. On the one hand, but on the other hand, incidences of negligence malpractice or unethical behavior by health practice do also occur. The summit then focused on the plans to reduce these incidences. I just need to explain this a little bit because people confuse it. In any health setting around the whole world, there are things which we call adverse events. If it was taking medicine, they'll call it side effects. Adverse events are events that happen to patients, as we said, the world over, which were not intended, but happen as a result of the treatment or management they'll be getting. On the other hand, negligence, malpractice or unethical behavior is what health practitioners do, which is obviously unacceptable and illegal. The second issue that was identified was administrative solutions. This entails proper keeping of good medical records, minimizing theft of medical records, and proper communication with patients and members of the public. And the third is the legal solution. That entails looking at various legal interventions, even before matters went to court. This includes, but not limited to, mediation processes, possible review of contingency fees, and staggered payment to claimants. However, the Department of Health noticed several claims which were completely out of sync and made no sense at all. There were claims that were evidently fraudulent. Even at a glance, you could see that this is fraud. Just to give you an example, a claim was submitted in which the claimant demanded 70 million rand for a supposedly botched circumcision by a doctor in a hospital in Limpopo. Naturally, we were curious. If somebody is undergoing circumcision, it gets botched, how much will that cost? Is it 70 million, 10 million? What is the cost of that? So because of that, we rushed to get the file from the hospital. That's Ledaba Hospital in Limpopo. And on examining the file, which we even sent to the then professor and head of surgery at Steve Biko Academic Hospital, Professor Taole Mugwena, who is now the health umbat after Professor Makhoba. We sent the file to him, and his report was that this patient needs to thank the state for saving his life rather than demanding 70 million. The simple reason was that no circumcision was ever performed on this person. The patient was actually treated for a very serious genital infection, which was out of his own carelessness, which I may not be able to mention here. So the hospital actually saved his life, but in return, he demanded 70 million rand. And we believe the reason that they were so brazenly demanding something that does not exist is because they were going to collude with some officials. So the SIU was called in to look into these very suspicious claims. In 2017, the SIU started their work by targeting provinces with the highest share of claims. And this province with the highest claims was Gauteng and Eastern Cape provinces. By that time, the Eastern Cape contingent liability in respect of medico-legal claims amounted to 15.9 billion, while in Gauteng, the figure of contingent liability was 21.2 billion. I've listened to the media, including this morning, and I think some of these figures are sort of confusing. Contingent liability is not the money that has been paid for medico-legal claims. is the money that is being claimed if they win. In other words, if all the claims that have been submitted are won in court, then the state will pay that money. But if they don't win, then it means that money will not be paid. Now that we call contingent liability. So the 15.9 billion is what lawyers submitted as forms of claim to the Eastern Cape Department of Health, and 21.2 billion was what was claimed from Gauteng Department of Health, and they were still to be proven in court. That was in 2017. Now, let's come to the general findings of SIU before we go to specific findings. Most of the claims were targeting cerebral palsy. This is a condition in which babies develop some form of brain damage due to deprivation of oxygen during the process of birth. For those who are medically inclined, I will say it's during the second stage of labor. While it is recognized that cerebral palsy is a very debilitating and unfortunate occurrence to come from the healthcare system, it is a matter of serious concern that this fact is abused by some legal practitioners due to sheer greed. The level of abuse was such that the SIU find that some of the claims were made on behalf of patients without their knowledge, meaning that there's a lawyer who has submitted a claim against the healthcare system for a particular patient, and that patient knows nothing about it. Number two, elderly people who are taking care of their grandchildren in the absence of their mothers were tricked into signing the power of attorney to sue the state, whereas they were told that they were signing SASSA forms for child support grants. This was very, very prevalent in the Eastern Cape, being a rural province where many mothers have gone out to work to fend for their children. The children are left with grannies, and these grannies becomes target of lawyers and their touts who come to them and say, we want to apply for child support grant from our child, please sign. When the granny is signed, that becomes a power of attorney, which they used to sue. This simply means that legal practitioners or their scouts were masquerading as social workers from SASSA. Now let me come to specific findings in the Eastern Cape. In the Eastern Cape, most of the medico-legal claims emanated from one Johannesburg-based law firm. We are able this morning to name the firm today because they've already been charged in a court of law. You are aware that the laws of the country say if you accuse somebody of theft or criminality or what, you can't name them until they appear in court. Now, this is to say, unfortunately today, we are not going to be able to name some of the lawyers, but we know them. The SIU has got them. But we may not name them until they appear in court. But this one we are naming because it's there in court. This is the Non-Nguba Attorneys Incorporated. In a period of 15 years, excuse me, it's 5 years. In a period of 5 years, that means from 2012 to 2017, this law firm alone submitted 44 medico-legal claims to the tune of 497 million against the Eastern Cape Department of Health. Most of their claims, as mentioned above, were of children supposedly born with cerebral palsy. We say supposedly because many of them were not actually. Now, cerebral palsy is not necessarily a homogeneous condition. This means that the effects of the brain damage are not the same for all individuals because different parts of their bodies might be affected. But however, claims submitted by Nonquba Attorneys Incorporated for each of the 9 children for whom claims were submitted at that time were identical in that he demanded 15 million. Or maybe let me put it differently for it to be understood. As Nonquba was submitting these claims, which we said were 44, 9 of them, which were for children with cerebral palsy, were all 15 million rand. And it was very suspicious. And we believe it indicates a lot of cut and paste, where you sue for one child, then you just run around the village, you're looking for some more children, and you submit the same claim, you just change the names. We think that's what Nonquba attorneys were doing. This is so because when people claim, they claim for things like future medical care, loss of earnings, loss of amenities of life, etc. They can never be identical for each and every person. But in this case, the 9 were identical. That's why we're very suspicious. Between 2010 and 2016, medico-legal claims increased from 46 to 529 in the Mthatha High Court alone. There is evidence of collusion between attorneys, touts, unfortunately nurses and doctors in both public and private healthcare. In some instances, nurses stole the medical records and illegally handed them over to attorneys. I was listening this morning to one of the TV stations when a representative of DINOSA was interviewed, and he mentioned something like this, that if their members' action need to be taken, I want to confirm to him that that was actually a finding. And how does it occur? The moment lawyers hand over a claim, which they know is fraudulent, they immediately send somebody to steal the file so that the health sector, the Department of Health, cannot prove that such negligence never occurred. And in all cases, if a file is lost, the judges rule in favor of the claim, of the claimant, because the government is not able to prove anything. And so these files got stolen. Out of experience, the 70 million rand claim I'm speaking about, I suspected that something like that was going to happen when I saw it. And the MEC in Limpopo was then Dr. Popira Matuba, the present premier. I said, drop everything you are doing, rush to Letaba Hospital, grab that file, because we know within short space of time, it will be gone. And that's how we found that no circumcision was performed. If that file was performed, we did not grab it, the judge was going to agree that we performed a medical circumcision and botched it, and so the patient will have to be paid. So this stealing of files is quite devastating to the healthcare system, and it's very painful that is done by health workers. Now, after this file is stolen, the attorneys will then apply through PAIA, Promotion for Access to Information Act, for the same record that they know they are illegally in possession of. In other words, you steal a file, keep it in your office, and go to apply via PAIA and say the hospital must give you the file, when you know very well that you have already stolen it. And so naturally, such a record will not be found. The hospital will search and search, go to the archives, search for many weeks on end. They will never find the file because it's in the possession of the lawyer. Then the lawyer will come and claim fees from the department for failing to produce records. And this was also found to be very prevalent. Unfortunately, very unfortunately, there was also collusion involving some officials in the office of a state attorney, whereby out-of-court settlements for hefty sums were entered into without the mandate or even the knowledge of the department. Remember, the people who are being sued here is the Department of Health. The state attorney are just legal representative of government. But many of them, I mean, in some instances, they entered into hefty sums of out-of-court settlement without the department knowing anything about it. Even in cases where the department will have been able to defend. Litigating attorneys will even sue for one case in 2 different courts. I'm sure you might be aware that our courts do not have an integrated information system. If the state in the form of NPA doesn't pick this up, it will happen that this one case of one patient is appearing in 2 different courts at the same time, or perhaps at slightly different times. A variation of this situation is where 2 different lawyers will claim for the same patient using identical details, but they submit them to different courts. Notably, whereas the patient is one person, the 2 attorneys will claim vastly different amounts. In the case of this patient, which you can't name, one attorney was claiming 7.5 million, and the other was claiming 25 million. But the condition for which they were claiming was the same. And you can see the difference between 7.5 million and 25 million. This clearly indicates that quite a number of claims were just arbitrary. You just sit there and write an amount arbitrarily without anything medically or legally informing you. Now, after these findings were made in the Eastern Cape, the National Health Council, which you know, is a National Health Council is what in other departments they call a MINMEC, where the MECs and the minister come together. But in the case of health, it is called National Health Council, not the MINMEC, because it also involved other other organs of state and other spheres of government, like it also involved the South African Military Health Services, but it also involves SAGA representatives. And unlike other MINMECs, it is actually a statutory body. The decisions which are taken there are actually statutory. So this council decided, after the SIU gave these preliminary findings about Eastern Cape, that all provinces need to be investigated in a similar manner. Hence, the SIU obtained Proclamation R74 of 2022 from the President of the Republic to conduct investigations all over. On the 29th of July this year, that's last month, the SIU briefed the department about progress in this regard. So I'll just summarize the progress. We are seeing progress because they are still very far from finishing. We just thought because it takes a long time, people believe nothing is happening. Advocate Mothibi, like yesterday, the claims that were made all over the media about the late Babita Diokren, that nothing is happening. I'm happy to hear that during the memorial, during the evening, you actually give details of how far you are. We are doing the same here because people might believe nothing has been happening about medico-legal claims. I also heard sometimes members of parliament also making similar statements. So I just want to summarize. It's in a form of a table. Firstly, let's start with Eastern Cape. Up to so far, 2,500 medico-legal claims that are valued at 22.3 billion have been submitted. And I repeat, the 22.3 billion is not what Eastern Cape has paid. It's what the lawyers have submitted. That we want money to, each one of them saying, I want this much. When you add, it's 22 billion. So the number of claims are 2,500. Now the SIU currently, out of this 2,500, is currently investigating 197 claims, which are valued at 2.3 billion. You can see It's still a tip of the iceberg. Out of 2,500 claims, they are still at 197 because it takes a long time. But the total amount that Eastern Cape has already paid, calculated from 2015-16 to 2020-21 financial year, that means within that 5 years, Eastern Cape has paid 3 billion 39,951,634.08. This is the amount that Eastern Cape has paid up to so far. Now the SIU, out of this 197 cases they are investigating, which are worth 3.8 billion, they've already completed 89. And these are to the value of 1.2 billion. So at the moment, they are still left with 108 out of this total they've already started investigating. And those 108 will be worth 2.6 billion. Now, what are the summaries of irregularities, specifically for Eastern Cape? We have mentioned them in general terms, but what is the summary in these cases that they've already completed? The SIU has finalized, that's number one, irregularity, has finalized its investigation regarding 23 letters of demands, whereby lawyers were demanding 298 million from the Department of Health. 15 of these 23 letters of demand, to the value of 271,800,000, were fraudulent because the claimants told the SIU during the investigation that they have never visited any of the health facilities that were being litigated against. And indeed, when the SIU went to the hospitals, they found no records of such patients, confirming the statement by the patients that I never went to that hospital, I don't know what you're talking about. Notably, all these letters were submitted by a single law firm, but this particular law firm, we are unable to name it because they've not yet been charged in a court of law. So we'll have to withhold the name of that law firm, unfortunately. Number two, these fraudulent claims were successfully removed from the contingency liability of the Eastern Cape, because if they are fraudulent, then they can no longer appear on contingent liability. The significance of this is that when the Auditor General audit books, they also calculate the contingent liability, and they issue the statement on the basis of contingent liability and start worrying and give that province a very negative overview, because they all know that the claims, the Auditor General won't know that this is out of fraudulent claims, so they have to be removed. Number three, there are 35 additional matters valued at 600 million rand currently under investigation, initiated by the non-Nguba attorneys, which we have already named, in which no trust were registered as per the court's orders. The SIU has made 45 referrals, that's number 4, 45 referrals of attorneys to the National Prosecuting Authority, amounting to 279.5 million for consideration of criminal charges related to fraud, theft, embezzlement of trust funds, and contempt of court against certain legal firms. These include the non-Nguba attorneys. Again, we are unable to name these certain legal firms because they've not yet appeared in court. The same attorneys were also referred to the Legal Practice Council, LPC, which you all know is a professional representative of attorneys. These matters have been referred to them for violation of the Code of Conduct of Legal Practitioners and the Legal Practitioners Fidelity Fund to consider reimbursing claimants whose funds were embezzled by the legal representative. I need to explain this. There is an institution called Legal Practitioners Fidelity Fund, where lawyers deposit money in case there is a suit against them. So when a patient is being cheated in the manner we're explaining here, because the lawyer will have already embezzled those funds, the fidelity fund will pay them so that they don't suffer damage caused by their own lawyer. So these cases have been referred by the SIU. 5, the SIU has identified numerous cases in the Eastern Cape where the living conditions of the claimants and their children remain appalling despite having received compensation from the department, which money has been paid to their lawyers. We are counting millions here that the department already paid in the Eastern Cape. But the patients for which they were claimed are living in abject poverty because they never received a cent. Many of these claimants are unemployed and rely on social grants from SASSA for their livelihood, despite millions having been deposited into their lawyers' account. Some households are constrained into a single room or a small rondavel without appropriate railing or ramps to assist disabled children, resulting in inadequate living conditions and insufficient caregiving, despite the fact that in the claims, money has been paid for this type of facilities. This means when the lawyer claims in court, he'll say, "My honor, I also claim so much money because this person is on a wheelchair, they need to access the house, they need to be railings and all that." But when you go there, there's no such. Whereas the judges agreed that that money be paid by the state, and the state had indeed paid the money, but the poor patient received nothing. Furthermore, the SIU found that these children continue to place a burden on the already strained public health care system, whereas in the claims in court, the lawyer cited future medical care based on fees charged in private hospitals. In other words, they'll say this child must get the best care in a private hospital, and we demand so much, and that money has been paid, but they will never see the inside of any private hospital. They'll still come to state hospitals. One notable instance, this is the last irregularity in the Eastern Cape. One notable instance involves cases where the department paid 373,850,748 rand 04 to non-mover, the attorneys have mentioned, for 22 claims between 2018 and 2021. However, several years later, an inspection by the SIU revealed that none of the claimants had trust accounts registered in their names as ordered by the courts, and their living conditions were found to be deplorable and impoverished. This means that non-Muga attorneys have pocketed all the money for themselves, and this matter is already before the courts. I want to explain because I hope members of the public are listening. When a lawyer sues the state on your behalf, the money so paid doesn't go directly to the patient. It goes to the trust account of the attorneys. The court will then rule that a trust account be opened by the attorneys on behalf of the patient. And this is what non-mover attorneys never did, meaning they keep the money for themselves. They are not the only legal firm that does so. Quite a number of them do. But as I said, we are unable to name them. Let's go to the Free State. 417 medico-legal claims have been submitted to the tune of 4.9 billion. 52 claims valued at 400 million are currently under investigation by the SIU. The Free State, over a period of 5 years, from 2016-2020 to 2015-16 to 2020-21, the Free State has paid 95,607,862 rand and 16 cents. Number of and value of cases finalized by the SIU is 30. 30 cases have been finalized to the tune of 280 million. A number of cases still under investigation by SIU, 22 cases which are worth 120 million. The summary of findings in the Free State: number one, the SIU has identified a matter where the claim was valued at 7.5 million, in which the lawyers went against the medical advice of their own expert, who advised them that there was no negligence on the part of the department. When the SIU confronts the lawyer, he then immediately withdrew the case. This means the lawyer went to his own medical expert, hoping to get the report to sue the state. And the medical expert wrote and said there's nothing to sue for. But the lawyer pushed that medical advice for his own expert and went to sue. But when the SIU confronted him, he immediately withdrew the case. Again, in the Free State, non-Nguba attorneys were found to be practicing without a Fidelity Fund certificate as required by law. This matter has been referred to NPA. So non-Nguba attorneys is not only in Eastern Cape, they are also found in the Free State. The SIU has made 17 referrals to the Legal Practice Council against 3 law firms, including non-Nguba, for misconduct related to touting for work, which is forbidden by law. The value of these referrals is approximately 78 million rand. Unfortunately, we are not able to name the other legal firms because there were 3. We are only naming non-Nguba again because the others have not yet been charged. The last finding in the Free State: the theft of medical records has been discovered in the Free State too, along with 2 other attorneys without withholding funds intended for claimants. It was found that in most instances, the hospital did not have these medical records. The problem involved 2 specific hospitals in the province. In one case, where a settlement for general damages was made, the court did not require the establishment of a trust. Instead, 6 million rand was paid into the claimant's attorney's account. The attorney firm paid the claimant 250,000 rand initially, and then 10,000 monthly. This irregularity is under further investigation by the SIU. As can be seen, this law firm is making undue benefits from the interest of the money that belongs to the patient. Let me go to Gauteng, which is the biggest up to so far, more than even Eastern Cape. 2,450 medico-legal claims have been submitted in Gauteng to the value of 24,445,550,786 rand. The number and value of cases currently under investigation by SIU, out of these 2,450, SIU is investigating 611 cases, valued at 4.1 billion. And the total amount of money paid by Gauteng over the 5 years, from 2015-16 to 2020-21, is 1.001 billion, to save time. The number of value of cases finalized by the SIU out of these 611, which are under their investigation, they finalized 58 cases valued at 66,015,000. And number and value of cases unfinalized is still 2,392 cases unfinalized, to the tune of 23.7 billion. Summary of electoralities in Gauteng. The SIU identified 40 matters involving claims submitted to the value of 496,650,000. 19 out of these 40 claims are on behalf of children who are actually deceased, but the lawyers continued with the claims. 2, I'm sure you'll understand why this is important. Somebody is late, but you continue with the claim, which might have started when they were still alive, but you are continuing. In the claim, you are claiming for future medical care when the person is already gone. You are claiming for loss of amenities of life. You are also claiming for loss of future income. 2 of the 40 are actually employed, whereas the lawyers have claimed for loss of earnings. 1 child actually had no cerebral palsy at all, whereas the lawyers were claiming for this condition. 9 claimants' attorneys withdrew when they realized that the SIU was investigating. The value of this case, the value of their claims which they withdrew, is 149,304,625. 1 case was struck off the roll, obviously because it had no merit. In all these instances of wrongdoing, the SIU will refer implicated attorneys and officials to the NPA for criminal investigations or charges, and the LPC, the Legal Practice Council. Let's go to the KZN, the 3rd province. Number of claims 2,440, valued at 29 billion. I made a mistake. I said this Gauteng, which is the biggest. The kingdom is actually the biggest. 29,140,032. 29,140,032,315 rand 42 cents. The number and value of cases currently under investigation, out of this 2,440, the SIU is investigating 713 to the tune of 8.7 billion. Total amount paid by KZN up to so far for the 5 years, reminding you 5 years is 2015-16 to 2020-21, is 1.3 billion already paid. Number and value of cases finalized by SIU out of this 713 they are busy with is 107 matters finalized, and the value is 2.4 billion. Number and value of cases unfinalized is still 1,420 to the tune of 18 billion. Summary of irregularities identified in KZN. Out of the 107 matters finalized, 76 relate to instances where claimants are actually deceased, and the value of 1.5 billion. This money has been removed from the contingent liability of KZN. 1 attorney was found to have submitted a claim to the value of 16 million rand after the death of the child. The child died first, and the attorney submitted a claim of 16 million rand. Significantly in court, the lawyer was claiming for future medical care based on private hospital rates and loss of amenities of life. This one will also be referred for criminal prosecution. Number 3, irregularity in KZN. The SIU has made 4 referrals to NPA and 3 to the Legal Practice Council against attorneys and private individuals who were found in possession of stolen medical records. This issue of stealing medical records, so these people have been caught and referred to. Now, all in all in KZN, all in all, 2,416,284,800 rand has been saved. It has been prevented by the actions of SIU. I'm sure you may just notice that this amount, just for KZN, is bigger than VBS amount. I'm saying so because in VBS, you see the headlines and all that. But here is some heist in one province bigger than VBS. The difference is that in VBS, victims were poor, women, funeral societies, etc. In this case, it is the state that is paying, but all of us in this room are victims because this is public money. So this money, 2.4 billion, has been saved. If the SIU didn't come in, this money will have been lost. Let me go to Mpumalanga. Mpumalanga, 419 cases submitted to the tune of 6.4 billion. A number of value of cases currently under investigation is 902 to the tune of 10 billion. Total amount paid by Mpumalanga is still 139. I want to explain. Mpumalanga is still really at the beginning of the claim, so there are not even irregularities found. They were the province that is lagging behind because the SIU might have gone to it much later. So let me jump to Limpopo. Limpopo, 1,600 medico-legal claims were submitted, and they are valued at 14 billion. Currently, out of this 1,600 claims, the SIU is investigating 303 cases involved, which are valued at 5.2 billion. Total amount paid by the department up to so far is 248,390,884.66. That has been paid by That has been paid by Limpopo during that period of 2015, 16, 2020, 2021. Number and value of cases finalized by SIU, they finalized 63 cases worth 139 million. And the number and value of cases unfinalized, meaning still under investigation, 698, which are valued at 2.7 billion. Summary of irregularities or wrongdoing found in Limpopo. Number one, the SIU identified 26 matters to the value of 657,291,825, in which the claimants were confirmed to be deceased. But the lawyers continued with the claims, in which they are also citing future medical care, loss of income, loss of amenities of life, as they've done in other provinces. These cases have been referred to NPA for criminal prosecution and the Legal Practice Council for professional misconduct by the involved lawyers. In another matter, that's number 2, irregularity Limpopo, the department paid 120,000 rand for the claims into accounts of the attorney's trust. Amazingly, the attorney kept their money. It's very little, but we are talking about the moral value of it. This happened in 2016, but the attorney did not release that money to the claimant. When the SIU have authorized investigating, the attorney gets scared and even paid double of the amount he was supposed to pay. I don't know whether he thought maybe the sentence will be lesser, but he didn't have to double the amount, but he did. The last, the amount of 657,291,824 cited above will be removed from the province's contingent liability. Limpopo is 657 million less liable than the lawyers had claimed up to so far, but you can see the SIU is still at the beginning. Northern Cape, 114 medico-legal claims to the tune of 1.5 billion have been submitted. Number and value of cases currently under investigation, 20 to the tune of 558 million. Total amount that has been paid by Northern Cape is 1.4 billion, which is very, very high compared to the size of the province. Number and value of cases finalized. The SIU has finalized only one case worth 23 million, and they are still left with 19. I mean, out of those which they are investigating, 19 worth 535 million. Summary of irregularities in Northern Cape. The SIU investigation uncovered a case where 31 million rand was deposited into the attorney's account to pay the claimant directly. However, the lawyer did not open the trust account as directed by the court order, which resulted in them keeping the money and earning back interest. This matter has also been referred to NPA and LPC. This is Northern Cape. In one instance, a lawyer was paid 18.7 million by the court. This was an out-of-court settlement. In other words, the lawyer claimed a certain amount of money But in out-of-court settlement, which was approved by the court, the lawyer got 8.7 million, but is paying the claimant only 6,000 rand per annum. Per month, sorry. Only 6,000 rand per month for the past 18 months. There's no indication that the lawyer was going to pay any other amount if the SIU did not intervene. This case has been referred to the LPFF, the fund I've spoken about, to reimburse the poor patient. And let me just summarize it. The lawyer received 18.7 million rand. But over an 18-month period until the SIU intervened, the poor patient was getting only 6,000 rand. If you calculate it, it was going to be 72,000 per annum. And this poor patient was only going to reach 1 million after 15 years, when 18.7 million in their name has been issued by a court of law. The SIU further identified 4 matters to the value of 169,400,000, all submitted by one attorney. The patients were interviewed and denied that they ever signed the power of attorney or instructed any attorney to lodge claims against the department on their behalf. 169 million, 4 matters where patients know nothing about, but we can't name the attorney again. This matter is being referred to the NPA and LPC. Northwest, 230 claims submitted to the tune of 1.5 million. Currently, 32 cases under investigation to the tune of 222 million, 222 million. Total amount paid by Northwest over the period 2015-16, 2020-21 is 122,491,200 is the lowest up to so far. Number and value of cases finalized, 12 to the tune of 32 million. Number of value of cases unfinalized, which are still under investigation by SIU, is 20 cases worth 190 million. Summary of findings in Northwest. The SIU found that 3 cases where 45 million rand was not deposited into the trust account for patients as required by the court. 3 cases worth 45 million was not deposited into the trust account for patients as required by the court. Instead, the money was placed into the attorney's trust accounts since December 2018, accruing interest rather than establishing a trust account on behalf of the patient. This matter will also be referred to NPA and LPC, NPA and NPC. Secondly, in Northwest, SIU discovered a case in which a claimant's attorney received 14,450,000 and only paid the patient 370,000. This money was deposited into the attorney's account in February 2021, but the attorney only paid the patient in May 2022. That means after 1 year of receiving 14.5 million, after 1 year, the patient received only 370,000. The investigation revealed that the attorneys acted fraudulently and in contempt of court. Again, we are unable to name the attorney, not yet charged. The attorney is not yet charged. And the matter is being referred to NPA and LPC. Western Cape, this will be the last province. Mercifully, the last province. Number of cases submitted, 409 claimants to the value of 2,852,588 rand, 588,055 rand and 99 cents. The number and value of cases currently under investigation, preliminary assessment of raw data, database of claims provided by the Office of the State Attorney, so it's still the beginning. But the total amount paid by Western Cape from 2015-16 is 273,248,535 rand and 91 cents. Number and value of cases finalized, I've already talked about preliminary assessment. Summary of irregularities in the Eastern Cape. The Eastern Cape up to so far. Sorry. My apologies. Maybe let me take some water.
Yes.
Yes, we are on Western Cape, the last province. In the Western Cape, they were hit by only one attorney, up to so far. I'm talking about the irregularities found, because the others couldn't be found because it's still preliminary assessment. But what has been found and finalized is one case. It's one lawyer. The SIU identified 33 fraudulent birth injury claims. That means cerebral palsy. In the contingent liability register to the value of 409 million rand. These cases include allegations of fraudulent medical negligence claims, and they were submitted by one legal firm, which is Nonguba, as we have said, on behalf of these various patients. Fortunately, none of the 409 million rand has been paid, and it will be removed from the contingent liability. So, in total, from 2015-16, 2020-21, all the 9 provinces have paid 7,749,478 rand and 45 cents. I'm repeating this because this morning I heard all over the media houses that provinces have paid 28 billion or 24 billion. I think we're somehow confusing the claims to the total amount of paid, and I'm repeating. All 9 provinces added together between 2015-16 to 2020-21 paid 7,754,478 rand and 45 cents. Now, so far, in the matters finalized by SIU, and as you heard the figures, it's still the tip of the iceberg because they are still at the beginning of the investigation. Regardless of the fact that they are already at the beginning, the SIU has saved the state the sum of 3,104,684,800 rand. This money will have been paid if the SIU did not come in. It has been saved for the department. And obviously you can see these savings are going to increase dramatically as investigation happens. So in conclusion, the relationship between the department and SIU in the fight against corruption will not only be limited to the medico-legal investigation, but will extend to areas of department where corruption rears its ugly head. This will include, among others, in the implementation of national health insurance, which many people believe is going to be planned on the foundation of corruption. Now, I want to assure you that that's not going to be allowed. We are already working together with the Health Sector Anti-Corruption Forum. That includes SIU. We're not going to allow any corruption just to happen under our noses. We've seen enough. There are naysayers that investigation by institutions like SIU are just for public relations exercise and are meant to yield no results. This was said by a prominent South African in May this year, just 2 weeks, 10 days before election, after the Department of Home Affairs called the SIU to raid the refugee reception centers in which many of you in the media attended. And this was done after a tip-off by a whistleblower. And somebody said, we know that these things are just happening for public relations. Now, I can assure you today, the results of those raids in the refugee centers will come out in the same way as the SIU started investigating medico-legal in 2017, and the results are only coming now. You know, the wheels of justice grind very slowly. But when they start grinding, they grind exceedingly fine. And this is going to happen. So those no-sayers who in May will say, no, this is just public relations before elections and all that, must know that the SIU, we already know some preliminary results, but today is not their day. We wish to take this opportunity, and I'm asking the media to listen carefully because I want you to come and help in this case. We wish to take this opportunity to make an offer to lawyers who might have knowingly submitted claims that are fraudulent, as happened, to come and withdraw them within 2 weeks, and there will be no consequences. If you are a lawyer out there, you have submitted a claim in the category of fraud, please come and withdraw them. Nothing will happen to you because you'll have gone. By the way, we didn't give you the figures of lawyers who withdrew in the Eastern Cape when they had that SIU is in. They came to withdraw. So we are calling on lawyers, please come and withdraw, and we are promising you publicly nothing will happen. And we are giving you 2 weeks. But failure to withdraw within 2 weeks will mean that the offer will lapse and the SIU will strike. Thank you very much.
Thank you. Thank you very much, Minister. And like I said, I hope you understand why I said it's going to be a long statement. But at the end, the intention is to give you enough information so that you understand where we are in terms of the investigation and the amounts that we are talking about. We have now reached that stage of this press conference where we're going to request if there are any questions. Maybe we must start outside. Oh, you want to start here? Okay. Let's take it 1, 2, 3 as it comes. You know what to do. I don't have to tell you what to do.
From News in Africa, to the ministers and the head of the SIU, please forgive me if some of the questions are not coherent because we are still trying to process the information that you gave us. It was quite comprehensive. But to start off where the minister basically finished, where he made a plea to some of the lawyers who have made claims that might be fraudulent to basically withdraw those claims. Is that not then going to be part of the problem? Because, Minister, when you started, you spoke about the road accident fund, and that when there was an investigation in that fund and the corruption in relation to that fund, that's when a lot of these lawyers jumped ship and started coming into the medical claims business, basically. So is that not where the problem is? And just to the advocates, I guess, when it comes to the road accident fund, the investigations that were done there, was there any prosecution of those lawyers? Or because of the lack of this prosecution, these lawyers basically were emboldened and they were able to go into the medical claims business? Also, Minister, you were able to name one law firm. And you indicated that this is because they've already been charged and I guess they are appearing in court proceedings. What is taking longer to basically charge the other law firms? Because it seems like there was this ability to charge this one particular law firm. Is it investigations are still ongoing when it comes to the other law firms? I'll allow my colleagues to take a bite.
Okay.
It's Rorisang from Times Live, Rorisang Khosana. Yeah, we have a long list of questions, but I'll just ask a few. For now, I'd like to know more about the state attorneys that managed to settle out of court without the knowledge of the department or notifying the department. Do you perhaps have the sum of the value, let's say, of these claims that were paid by the state attorneys, and what is going to happen to these state attorneys? Are they also going to be referred to the LPC? And then another question, these two provinces, or three, it was Eastern Cape, KZN and Gauteng, which hospitals were mostly targeted or accused, let's say, of medical negligence? That is my questions for now. Thank you.
Thank you. Aviram Dila from ENCA. Firstly, Minister, were you aware, I understand you were Health Minister at the time, 2016 till 2019. Were you aware of some of these claims at the time, and maybe could you have done anything differently? Also, now that this has come out and these findings have been done by the SIU, are you looking at maybe closing the loopholes? In what way to stop the greed of the lawyers? And also, have you taken action on against some of the employees of the Department of Health itself? You mentioned also, Minister, that the claims, a lot of them don't go to the actual claimants, and being the patients that were affected by some of these. Is there means to make the money that's been recovered go back to them? And also, maybe on a broader look at the health department itself. For example, we saw in the memorial of Babita Deokaran yesterday that 3 billion of corruption was unearthed by the SIU just in Tembisa Hospital alone. And it's concerning at what's happening at the other aspects of the hospital. Will you be looking deeper perhaps into that? And we also heard maybe for the MEC of Health in Gauteng, just around the HOD of the Department of Health possibly being investigated by the SIU. Can that be confirmed if it is in fact happening? Thank you.
Thank you. I will allow for responses, and then we can take it from there. Who is starting?
Advocate, there are two questions for you. I don't think it must be answered by the MEC if you are investigating. There are things. And then, what took long to charge other lawyers which were unable to name? Yes. I think those are the two for me. I'll keep the rest.
Thank you. Thank you very much for the opportunity. Honorable Minister, Honorable DM, Honorable MSC, members of the media. The road accident fund question, is it because the lawyers were emboldened because of the failure of the prosecution? As you may be aware, that we do have a specific proclamation under which an intensive investigation is happening at the Road Accident Fund. And there are findings already there that we have really gone public on. I think even when we presented to the to SCOPA in Parliament, a number of attorneys there, a similar phenomenon that we are seeing here, that when we made findings against them around, fraudulent claims and so on, they came forward, and paid back, the monies. But over and above paying back the monies, we have also, as in this case, referred them to the Legal Practice Council and to the National Prosecuting Authority. So as you know, that once we refer evidence to NPA, they also have a duty to go through, the evidence, and of course satisfy themselves that they can make a decision either way, whether to prosecute or not to prosecute. But that's also on their part, a process that they follow. Right. The issue around I'll just go straight to the issue around the head of department at the Department of Health, whether he's under investigation or not. This question came up yesterday evening at the memorial service of Babita Deokaran, and my response was, I will need to verify with the Gauteng head or Gauteng investigating team, because more often, these referrals are made to the investigating teams and so on. We did not have the actual response, and we did not want to mislead the public then. Overnight, we could not get that verification, so we will still verify. And of course, you can come back to us where we can give you, a response. And of course, we will also inform the ministry and the MEC, because now it has come out public. We'll really inform them whether it's factual that is under investigation or not.
What took longer to charge others?
Yes,
Other than no.
that's right. I think the response there is that, as you can see, the investigation is really quite complex. I think the issue around Nonguba, the reason why we are able to mention is because we started way back in the Eastern Cape, right? And perhaps the details of that is even before the proclamation was signed in 2022, we had already started investigation together with the Department of Health at the time, right? And how did it happen? As a question may come up, that why do you investigate without a proclamation? More often, the public really sees investigations that we conduct under proclamation. But there is a provision in our legislation which says we are able to second the SIU officials to state departments to start these preliminary investigations, which will allow us to gather information to then draft a proclamation. So this is how it happened. So at that time already, when we were, had seconded our officials to the Department of Health in the Eastern Cape, we already uncovered the activities of Nonguba, and then we were able to, because they are quite magnitude as well. It's not a small amount of claims. We took a while, but we were able to finalize them with the department and then deal with him at that time. So the others came, once the proclamation came up. So the Nonguba one we were able to process, and you can realize that these actually have footprints in other provinces. So when we analyzed his claims, we looked at other provinces as well. It's quite magnitude. So we already started the Legal Practice Council with him, and matters are already in the High Courts, in the Western Cape as well, where we really would like the courts to ultimately strike the firm Nonguba Attorneys Incorporation of the practice role, and of course the criminal charges have followed. They've already appeared in court, and other professional misconducts. Thank you, Minister.
Thanks a lot, Advocate. Junior, your first question is whether lawyers won't get involved and whether it's not the cause of the problem to withdraw. But let's look at practicalities and be pragmatic. In Gauteng alone, as I've said, the claims are 2,450. The SIU is busy with 611. They've only completed 58. They are investigating in RAF, in Tembisa, and many other places. It's a lot of work. They will arrive there, but the question is, after how long? Now, we are extending a hand of friendship for lawyers to change their mind. Let them be visited by their God or the angel Gabriel to warn them against the immorality of what they are doing. And we are saying when they do so, they will withdraw. There will be a withdrawal. I gave you an example of this 70 billion rand in Limpopo. All we did was to ask the attorney to, after Professor Mugwela made this finding, he said, no, bring your patient to be examined by our own professors. they immediately withdraw. I was very unhappy, I must tell you, but I realized later one got to be pragmatic. I was fighting with the police. They said, no, this guy is withdrawn. I said, no, he must still be charged. In the same week, there was a claim for cerebral palsy that never happened in Donald Fraser Hospital in Limpopo. And we brought the patient here to be examined by Professor Smart, who is the professor of pediatric neurosurgery at Steve Biko. And she found no cerebral palsy, and they immediately withdrew. We left them. We can still charge them, but as I'm saying, there's a lot of work, and we are just saying come and withdraw. And as it has already happened in the Eastern Cape, by the way, lots of them were withdrawn just by hearing that NPA is there. Now we are asking you to spread the message. Lawyer, please. Yeah. Did I say?
NPA.
Oh, sorry. Even yesterday I kept on saying NPA. I don't know what's wrong with me. So we are asking you to help us with your media channels. Lawyer, please. The game is over. Come and withdraw, and nothing will happen to you. But if you don't withdraw, certainly something's going to happen, because they will still reach you. Rory Sang, the issue of state attorneys doing out of court settlement is part of the investigation that are ongoing. Is there anyone? It's possible that they might have done out of court settlement innocently or out of not understanding, but then the question will still arise. Why you do that without a client? Remember, we as department are clients of the state attorney. Just like you become a client of any other lawyer who represents you. You won't be happy if that lawyer makes an out-of-court settlement and you knew nothing about it. Lawyers must work on the basis of instruction by clients. And so the NPA, the SIU rather, will help us in that regard. Which hospitals were mostly targeted? Without checking, I'll say in Gauteng is Chris Hani Baragwanath Hospital. And I've seen ENCA has got somebody placed there at Chris Hani Baragwanath Hospital, and on the bottom there, it was written negligence. I don't want to defend Chris Hani Baragwanath Hospital. It's to be expected that in Gauteng they will be the topmost, for the simple reason that Chris Hani Baragwanath Hospital is huge. I've said it before, that we're not supposed to have allowed such a hospital to exist. And we're still having plans to cut it down into components, because according to standards from the World Health Organization, no hospital must have more than 1,200 beds. If you do that, you won't be able to manage it. And that's what's happening at Chris Hani Baragwanath Hospital. The last time I counted, I don't know MEC, it was 2,800 beds.
888 now.
888. What happened to the rest?
2,800.
Yeah, 2,000. I was going to be surprised. The last time I checked, it was 2,800. So you see, it's 2,888. And a normal hospital must be 1,200. If the hospital goes beyond that, it starts having problems. That's what Chris Hani Baragwanath Hospital is. Remember that it was built for Soweto, which is huge, the biggest township in the country. And they kept on extending it. But now the time has arrived that Gauteng, you remember they did build other hospitals like Mpumalanga to try and relieve Bara. But the size and the rate at which Soweto is growing and other settlements around is just not enough. So for that reason, you will definitely find this type of problems. It's simply on the basis of sheer numbers than anything else. The Aviwa, you are asking me about 2015, 2016, whether I was aware as a minister then. I thought I've informed you that in 2016 we called a medico-legal summit because of this awareness of the explosion. The reason that we called the medico-legal summit because we were sitting there and seeing escalation of claims, and we said something is happening here. And then we also learned that the private sector, that's why they were in the summit. Here the NPA, the SIU, oh my God. The SIU is not investigating private, but let me tell you what's happening. I promise you, now you remind me. the most targeted people are obstetricians and gynecologists, because pregnancy and childbirth can have complications, as you can see, cerebral palsy. So those colleagues who are in private practice, who are specialized in obstetrics and gynecology, are the most targeted, followed by neurosurgeon and spinal surgeon, because operating somebody on the brain and spine, you may not get 100% results. Then they are targeted so much that in private practice now, the Medical Protection Society, the society where doctors must go to buy indemnity, because you have to buy indemnity by force. Those who do not understand, like when you buy a new car, you have got to insure it, otherwise the bank won't agree to finance you. So here, when you start a medical practice, you have got to pay indemnity. That's insurance in case they sue you. Now, to be an obstetrician and a gynecologist in South Africa today, before you open your practice, you must put 1.3 million on the table for indemnity. Imagine, yes. They must buy indemnity for 1.3 million even before they open the practice, which means you must be rich already before you open that practice. Where are you going to get the money from? And so what's happening in South Africa now is that many obstetricians and gynecologists no longer practice obstetrics. You'll be aware that gynecology are diseases of women. Obstetrics specifically means pregnancy and childbirth. We had women who come and say, look, I've been going through, to this doctor for ages, but now I'm pregnant, he can no longer want to see me. Because he's scared of being litigated on, which means what? Women are very soon no longer going to find gynecologists. So the results of this thing is manifold, as I may put it. Now, it has also resulted in doctors doing what we call defensive medicine, where when you got into the rooms of a doctor, he doesn't look at you sympathetically as a patient. He looks at you as a potential litigant, that you are going there to come and litigate against him if you made a mistake. What then will doctors do in defensive medicine? They'll order investigations that are not necessary to cover themselves. He will do an X-ray and say, yeah, I found what I wanted to see. But then you'll say, oh my God, what if this person goes to court and the lawyers ask me why I didn't do a scan? What am I going to say? Then you'll say, medically, I can see a scan is not necessary, it's not indicated. But why not do it? It's the patient who's going to pay anyway. So they will do the scan and look at it again and say, what if they say I should have done an MIR, magnetic resonance imaging? I don't need it. But if they ask me in court, why not do it? It's not me who's paying. The patient is going to pay anyway. So you keep on ordering. This is what is happening in America, which has ratcheted the cost of healthcare in America. South Africa is right on the footsteps of America, to an extent where the former Director General of the World Organization asked me a question in Geneva when we were there for the World Medical Assembly. He said, Minister, tell me, in South Africa, your healthcare system is British. You are running a British system, which is true. Our curriculum is British. Our degrees are British. Because they were our colonizers. Even up to today, our nurses training is British. She said, everything you do in healthcare is British. But when it comes to healthcare financing, you go American, which is the system of healthcare financing we are following, which is American. The British system, as you know, they are following the NHS, which in South Africa we call the NHI, which all of you in front of me are fighting ferociously. But that's what the British system is doing, and it's saving them money. But in South Africa, we followed an American system. Because of this American system, let me give you figures. 43% of all the money that is spent in healthcare in the world is in one country, it's in America. All other countries of the world remain with sharing among themselves the remaining 57% of the total world healthcare expenditure. That's America, and yet we are moving in their footsteps and doing everything that the Americans were doing. That's why Dr. Chan asked me, at what stage did your country deviate from the British model and follow the American model? She even said the American model is the worst that America ever bequeathed to the world. That's why Barack Obama tried to change it with what is called Obamacare. The name Obamacare is a nickname, but it was masking the actual aims of Obama. The actual full name is affordable health care. He said America must start now going for affordable health care because what they are doing is not sustainable, which is also, of course, not sustainable in South Africa. So we became aware of this, and we were worried, as we were saying in private practice. There is a professor who told me, he didn't hide it. He was a professor, I'm not going to name the hospital, but he also had this private practice. He then said, Minister, in my private practice, I don't want to see any pregnant women. I refer them to the hospital where I'm a professor so that they can sue the state. In my practice, I'll only see gynae because there are not many litigations against gynae. So the whole practice of medicine is changing in form and content because of this type of behavior. Action against employers, yes. Any employer who is found to be part of this collusion, the SIU will charge, will send to NPA. Like we have told you about nurses who steal records. I have seen in some of the reports, especially Auditor General, where she's blaming provinces for not keeping proper records. I may not stand against that and say they are proper records, but I can assure you most of them are stolen, as we have already said here. And the only thing that will help us if we have got electronic records, which we are working around the clock to have them, but it is health workers who are also helping. Look, there's financial incentive here. If a lawyer knows that he's claiming 35 million or 18 million, which I said the lawyer received in Eastern Cape, in Northern Cape, and they offer a nurse just 1 million or even 250,000 just to steal a file, they will do it, unfortunately. Because wherever there is money, there is evil. Whether, Avia, you also ask whether we'll recover money. But I thought I've explained it, you might not have picked it up. I said the legal practice provident fidelity fund, legal practice fidelity fund, LPFF, was established specifically to reimburse patients who might have been cheated by lawyers. Because by that time, the lawyer might have charged the money. He has got nothing, you can take him to jail and arrest him and strike him off the roll. But what is the poor patient going to get? So that fund was established to reimburse them. And as I've already said here when I was reading, some of them have already been reimbursed by such a fund. But then the lawyer must go and answer in court through the NPA and to their legal professions council. Yeah, I think we have answered all the questions. Thank you.
That is it.
Well, a media briefing there by the SIU as well as the Health Department. Startling uncovering of widespread corruption when it comes to medico-legal claims. What we're hearing from the Minister of Health, Dr. Aaron Motsoaledi, him indicating that so far, with matters that have been completed by the SIU, a sum of over 3 billion has been saved from various departments of health. And most of these claims, of course, what we're hearing now is that concerns also from the legal fraternity, lawyers that have been involved in this kind of corruption, trying to swindle the state out of millions, also running into billions, of course, and highlighting some of the provinces, for example, where this has taken place. If you look at in the Eastern Cape, we're hearing from Advocate Andy Mothibi, who is the head of the SIU there, indicating that their investigation had started in the Eastern Cape, and just there alone, the number and value of claims that were submitted to the department by attorneys were 2,500 medico-legal claims valued or to the tune of 22.3 billion rand. Also, if we take a look at the Free State, 417 medico-legal claims valued at 4.9 billion rand. Of concern, of course, Gauteng. That would have been an expectation. That's where most of those medical or medico-legal claims would have come from. 2,450 medico-legal claims with over 24 billion, if I'm reading right here. And certainly investigations, that of course you would know. This press conference also coming on the backdrop of what we've already seen in the media and what we've been running this morning pertaining to the Gauteng Health Department. You would know that Babita Deokaran was one of the whistleblowers who was shot dead. It was the anniversary of her death just yesterday, and it certainly seems like the figure which had been uncovered with regard to the corruption that had been taking place at the Tembisa Hospital, now certainly running into billions of rand, and certainly with the SIU continuing with its investigations, more of that money is likely to be uncovered there. So the Health Department, together with the Special Investigating Unit, talking about over 3 billion that has been saved. If we talk about how much certainly that has been lost, that is also raising concerns. But what the Health Minister was also indicating to, there's an olive branch that is being extended here to lawyers who have submitted some of these fraudulent claims. They are being given 2 weeks in order to withdraw those claims, and the minister says nothing will happen to them because as it stands, the SIU is going to continue with its investigations, and more is likely to be uncovered. All right, we take a short break. When we come back, we'll have more news before we leave you at 12.